Hello everyone, welcome to the U.S. Immigration Hub. Breaking news. A dramatic shift in America's immigration system has sent shockwaves across the nation, altering long-standing expectations about citizenship, family policy, and the future of immigrant communities. Families are searching for answers, states are battling in court, and federal agencies are adjusting day by day as the rules governing who becomes an American at birth undergo their most consequential transformation in more than a century. Tonight we break down exactly what has changed, why it matters, and how millions of families may feel the effects in the months ahead. This is USA State. Before we begin, make sure to subscribe, like, and share to stay informed with the most accurate and essential updates on U.S. immigration news. For generations, the principle of birthright citizenship has been one of the most familiar and defining features of the American identity, a guarantee that any child born on U.S. soil would be recognized as a citizen. But that era has now changed. After years of political debate, court battles, and proposed reforms, a new executive directive has fundamentally reinterpreted how citizenship is granted at birth. Under the new framework, a child born in the United States will automatically receive citizenship only if at least one parent is a U.S. citizen or a lawful permanent resident. Birthplace alone is no longer the deciding factor. This development represents one of the most substantial adjustments to U.S. immigration policy in modern history, affecting families of every background, nationality, and legal status. Children born to undocumented parents, temporary visitors, international students, and long-term residents without permanent status are no longer automatically recognized as citizens. Federal agencies were quickly instructed to update their procedures, leading hospitals, administrative offices, and state agencies to verify parental immigration status at the time of birth. The result has been a dramatic nationwide shift in how citizenship documentation is issued. Families across the country have responded with confusion and concern as they attempt to understand what these new requirements mean for their children's access to healthcare, education, identification documents, and essential services. For many, the questions have extended far beyond paperwork. Parents are, really worried whether their newborns might face legal complications later in life, including things like difficulties obtaining passports, accessing benefits, or even traveling internationally. In some rare situations, a few legal scholars have raised the possibility that a child could actually become stateless if neither the United States nor the parents' home countries automatically recognize them as citizens. Legal challenges to the directive began almost immediately. Civil rights groups, immigration advocates, and coalitions of state governments filed lawsuits arguing that such a monumental change to birthright citizenship just can't legally be implemented through executive authority alone. They claimed that the directive actually contradicted more than a century of legal interpretation and should require congressional action. Several lower courts issued temporary blocks, preventing the directive from taking effect in certain states while litigation moved forward. This, created a patchwork of rules and left many families uncertain about which standards applied where they lived. But the legal landscape shifted again when the Supreme Court issued a decision that reshaped the situation. The court did not rule directly on the constitutionality of the directive itself. Instead, it determined that lower courts did not have the authority to issue nationwide injunctions against this type of federal immigration policy. As a result, the directive became enforceable across most of the country, while only a few states maintained temporary protections due to ongoing lawsuits. This ruling allowed the new process for determining citizenship to move forward. Even though the broader constitutional debate continues, the effects vary across the country. In states where the directive is still paused by court order, the process for issuing citizenship remains unchanged for now. But in the majority of states, families must now provide expanded documentation to establish parental legal status at birth. Hospitals have modified registration procedures, state offices have introduced new verification steps, and agencies have updated their internal guidelines. Social service organizations have reported a dramatic increase in requests for guidance as families try to understand how the rules affect their specific situations. Community groups, immigration attorneys, and advocacy networks have started hosting informational sessions to help parents prepare for the new standards. Many families, particularly those with mixed immigration status, are seeking advice on what documentation they need to have before a child is born. Agencies have recommended that parents gather immigration records well in advance of hospital visits, signaling just how deeply the process has changed. As the birthright citizenship debate intensifies, a separate but highly significant development has emerged in the area of family-based immigration. Federal authorities have introduced enhanced review requirements for I-130 petitions, which U.S. citizens and lawful permanent residents use, to sponsor immediate family members for residency. Historically, the I-130 process focused on proving relationships through clear documentation such as birth certificates, marriage licenses, and identity records, but under the new guidelines, the scrutiny applied to each petition has expanded significantly. Applicants now report longer forms, more detailed personal and financial questions, and additional requests for evidence. Some describe the process as more intrusive, while others say it requires gathering documents that many families may struggle to obtain. These enhanced reviews apply across the board to spouses, parents, children, and siblings seeking family reunification. These adjustments signal a larger philosophical transformation in the United States immigration system, one that places stronger emphasis on documentation, verification, and detailed review not only for humanitarian and employment categories, but also for traditional family-based pathways. Advocacy groups argue that these changes could create new obstacles for families who already face complex legal hurdles, while supporters of the policy say it ensures a more consistent and comprehensive approach to immigration review. Across the nation, public debate continues to grow. Some Americans see the new birthright citizenship standard as a major turning point that brings the United States closer to many European and Asian countries, where citizenship depends on parental status rather than birthplace alone. Others believe the policy undermines long-standing American values and threatens to create generations of children living in uncertain legal situations. While several countries in the Western Hemisphere still provide unrestricted birthright citizenship, the United States has now moved into a different category, one that reflects a global trend toward more regulated pathways to citizenship. The full impact of these changes will unfold gradually, shaping communities, influencing legal standards, and driving political debate for years to come. In this rapidly evolving environment, staying informed has never been more important. Families navigating visa applications, sponsorships, citizenship questions, or new immigration procedures must stay updated on federal guidelines and legal developments. With additional policy actions expected in the coming months, clarity and preparation are essential for anyone affected by the shifting landscape. This is USA State. If you want continuous updates on the policies shaping America's immigration future, make sure to subscribe, like, and share.